Mr. Hapgood.
May I please your lordships? On these appeal, I appear with Lord Panic QC, Brian Green QC, and Alan Roxburgh for the appellants, the Samba Financial Group. And my learned friends, Mr. Mark Howard QC, Mr. David Brownbill QC, and Adam Clockety appear for the respondents. The first three respondents are the joint official liquidators of the fourth respondents, Sickle Investments Company Limited,
Yes.
otherwise known as Sickle. My lords, the primary issue on this appeal is whether it's possible for a trust, which is arguably governed by the law of a common law jurisdiction, here the law of the Cayman Islands, to confer an equitable proprietary interest on a beneficiary in an asset whose lex situs does not recognise the concept of separate legal and equitable title.
Yes.
And that gives rise to two sub-issues. The first is whether the primary issue is governed by common law, in which case we say you have to go to the lex situs, or whether it is governed by the provisions of the Convention on the Recognition of Trusts. If it's governed by the common law, we say that the law of the lex situs is the law of Saudi Arabia, and it is common ground that the law of Saudi Arabia does not recognise equitable interests. So that's the first sub-issue. The second sub-issue is whether, if the primary issue falls to be determined under the Convention, the creation of such a trust is contrary to a mandatory provision of Saudi law, with the result that by Article 15 of the Convention, all other provisions on recognition have to yield to Saudi Arabia. So in a sense, one can label those the Article 4 issue and the Article 15 issue. Put more generally, we say that it was not the intention of the framers of the Convention that forms of property right unknown in non-trust states should come into existence and be enforceable in relation to property situate in such states. Now, my lord, the common ground is recorded in one paragraph of the Statement of Facts, which I would like to take you to, if I may.
Very well.
It's in Core Volume 1, paragraph 17, MS page 67.
Yes.
And this common ground comes into the argument at a number of points. It is common ground A, that Mr. Alcinier was the legal owner of the disputed shares prior to the transfer to Samba, and that's because he was registered as the owner on Tadawal, which is a Saudi Arabian stock exchange. B, the lex situs of the disputed shares is the law of Saudi Arabia. C, this is the important one, there is no means of creating separate legal and equitable proprietary interests in property under Saudi Arabian law.
Right.
That is common ground, and I stress that because when the Court of Appeal came to deal with the Article 15 issue, they essentially concluded that it raised issues of fact about Saudi law which couldn't be resolved without a trial. And we say that in the light of the common ground, that was wrong, because the only point which mattered for this purpose was that you couldn't create a beneficial interest in Saudi shares, and so there would have been no point in going to a trial.
Yes.
And then D, that the Saudi Arabian courts apply only the law of Saudi Arabia and will not apply or even consider the law of a foreign country. In a sense, that's a slightly peculiar feature of the case in the sense that there will be issues relating to civil law states where that principle does not apply. But that is not a point of common ground on which my argument fundamentally rests. Now, can I next take you very, very shortly to one of the share sale agreements and one of the declarations of trust, I do so because, in particular, the share sale agreement recites a fact which is quite fundamental to the issues before your lordships. It's the 2003 share sale agreement, and that's in Core Volume 2, MS page 359.
359?
Yes.
Thank you.
Uh, 2003 share sale agreement, an agreement made the 17th day of December 2013 by and among the following: Ahmed Hamad Al Ghasobi Brothers Company Limited, Sickle and Al Sanir, who is described as the nominee. And under the recitals, recital 3, whereas Sickle cannot hold legal title to such shares, and the nominee is willing to hold legal ownership of such shares as nominee for Sickle in order to comply with legal requirements in Saudi Arabia. And you should note that this is all common ground, that this nomineeship arrangement was not registered or documented on any public register whatsoever, so that parties such as my clients are dealing with Mr. Al Sanir, qua registered owner of the shares. That's from their standpoint, that is what he appears to be. And then by section 1.1, Algamy agrees to sell to Sickle, and Sickle agrees to purchase from Algamy all right, title, and interest in and to the shares detailed in Schedule 1 of this agreement, and on and subject to the terms and conditions precedent.
Yep.
And then there's provisions for delivery of a bill of sale, etc. Doesn't actually refer to a declaration of trust at all. Now, in terms of the declaration of trusts, can I take you to the first one of those in the same bundle, MS391.
Yep.
This is the declaration of trust of the 5th of June 2006.
Yep.
And as your lordship see, it's a very short form declaration of trust indeed. 3.A, the trustee declares the assets described in the schedule to this declaration, those standing in the name of the trustee, in fact belong to the buyer, and B, undertakes to hold those assets in trust for and to the order of the buyer, and at the buyer's expense to transfer them or otherwise deal with them and any rights associated to them as directed by buyer, and to complete all documentation necessary for that purpose. Now, may I next come to the scheme of the convention.
Mr. Hapgood, are you going to come at any point or start at any point with the actual claim in the case, which is by the liquidators to avoid a property disposition? Because for my part, I'd just like to satisfy myself that the only way in which there could be said to be a property disposition is if there is some proprietary interest which would be enforced in whatever jurisdiction one is treating as relevant. Do you suggest that any other interest which would be of an arising is completely irrelevant because it's not property?
Yes, I do, yes.
Is that in issue in the case?
Well, it hasn't been in issue in the courts below.
Hasn't. But I mean, are you suggesting, maybe it hasn't been discussed therefore, but are you suggesting that this trust, if you're right, in relation to Lex Citus, has no effect at all in terms of conferring any rights on the claimants on
Sickle?
SI on Sickle?
I'm not suggesting, by way of a positive case, that it conferred no rights on Sickle. I'm making 2 points. One is it did not confer a proprietary right on Sickle.
It conferred a right to have the property, but you say that's an in personam
Yes,
right.
if they had any right, it's in personam, and that doesn't concern us.
And you say that the fact that Mr. Alsana allegedly gave away property which he should have held, even if only in personam, for Sickle, is not a disposition of property and or
Not for Section 127, no.
has that been conceded? Is that
Well, I think effectively it has, because we've argued the case on that basis.
I see.
It would simply sound in some personal remedy, such as damages or
Yes,
a form of equitable restitution.
yes.
You would have a right, I mean, if the property was still around, you would have a right to specific performance, but again, you'd say that's irrelevant. It's
That's
just
irrelevant,
a right
yes.
to receive property, not a property right.
Yes,
Section 436, the definition of property includes every description of interest arising out of property.
Yes, MS 1774.
yes, but the effect where Section 127 applies, the disposition is void, and you're avoiding the disposition of a property interest.
Well, an interest, or it could be, an interest arising out of property,
Yes, well,
Incidental. Yeah.
or incidental to.
But there would have to be a property right for it to arise, for anything to arise out of it.
yeah.
Thank you.
Well, a thing in action is included in property.
Well,
The answer is it hasn't been raised.
well, the answer hasn't been raised, and the answer is that what was disposed of, I mean, Sickle has not lost its in personam rights against Mr. Alsania. They've not been disposed of. All we've taken is the legal title to the shares.
Yeah.
Yes, the amended particulars of claim allege that relief is sought against Samba on the ground that the disputed shares were assets owned by Sickle. That's Core Volume 1, page 63, and I'll give you the MS reference in just a moment. 283,
MS 283,
yes.
283.
or bundle 2.
Is that mine?
What paragraph?
Paragraph
Yep,
57, sorry, 37.
37. Oh, yes, I see. Yeah. Yep.
Now, if I may please go to the scheme of the convention. It's an authorities, Volume 1, Tab 1, MS, page 982.
Yep.
Start with the Act itself.
Yep. Yep.
And subsections 1 and 2 come into the argument. By subsection 1, 2, these provisions shall, so far as applicable, have effect not only in relation to the trust described in Articles 2 and 3 of the Convention, but also in relation to any other trusts of property arising under the law of any part of the United Kingdom, or by virtue of a judicial decision, whether
Yep.
United Kingdom or elsewhere. And that's important because that's why the Convention comes into the Scottish case, the Rangers case, which I'm going to come on to in due course. And then subsection 1.3.
Are we really going to be helped by a finding of a Scottish judge as a finding of fact as to what the English
You're not
law
going to be
is?
helped by a finding of fact, but you will be helped by Lord Hodges' observations on Articles 4 and 15 of the Convention.
I see. Okay, fair enough.
And then, in accordance with Articles 15 and 16, such provisions of the law as are there mentioned shall, to the extent they're specified, apply to the exclusion of the other provisions of the Convention. So, in effect, that makes Article 15 and 16 mandatory. Now, the core provisions of the Convention itself are, for our purposes, are 2, 4, 8, 11 and 15.
Yep.
By Article 2, for the purposes of this convention, the term trust refers to the legal relationship created inter vivos or on death by a person that set law when assets have been placed under the control of a trustee for the benefit or for the benefit of the beneficiary or for a specified purpose. Just pausing there.
Yep.
It is a fundamental concept of the Convention, however artificial one may think it is, but it's a fundamental concept that there is a two-stage process. At the first stage, assets have to be placed under the control of a trustee. And we say all of that whole stage, we say is taken outside the scope of the Convention by Article 4. And then there's a point when the trust comes into existence, which is governed as to its internal management and effects by Article 8, and as to matters of recognition by Article 11.
Yep.
And it's a the focus is on the legal relationship, which is created at stage 2. Now, it then specifies the characteristics of a trust. A trust has the following characteristics. A, the assets constitute a separate fund and are not part of the trustee's own estate. B, title to the assets, trust assets, stands in the name of the trustee or in the name of another person on behalf of the trustee. And then C, I think, doesn't help us. Now, the significance of that definition is that it doesn't take the common law definition of a trust. It doesn't define a trust by reference to the creation of an equitable proprietary interest. In other words,
It is dealing with proprietary interests and not just personal ones, isn't it? Because the second half of A provides that they're not to be regarded as part of the trustee's own estate.
yes, but that's because the civilian concept, the civilian counterpart to our common law trust is fiduciary patrimony. The general rule in the civilian systems is one indivisible patrimony, but many civilian
It's
systems...
essentially the obligation in C.
Well, the obligation in C...
That's the essence of the patrimonial obligation, isn't it, in civil law?
Well, it may be the essence of the obligation, but A is an essential feature of a fiduciary patrimony. In other words, in the civilian concept, the beneficiary doesn't get an equitable proprietary interest, but he has a right which is good as against the trustee and the trustee's creditors, because the assets within the trust are not within the trustee's personal estate. Yes, I'm going to come on to that, yes.
Do the authorities include any works which will help us on the characteristics of a patrimonial
Yes,
asset? Right.
yes, there's some quite helpful stuff.
You're going to
from-
refer to that later, are you?
Yes, Professor Hayton has written very, very widely on this area. I'm going to take you to what I think is his most illuminating article, which explains all this. And yes, thank you. I'm grateful, Mr. Roxburgh. He points out that in the Scottish Law Commission discussion paper on the nature and the constitution of trusts, and this is Authorities, Volume 9, at page MS 3816, there are 3 paragraphs headed the dual patrimony theory,
Yes,
and that's paragraphs 216, 217 and 218.
yes.
And indeed there are et sequa, and that's all helpful background to understanding this concept.
Thank you.
Now, moving on then to Article 4, the Convention does not apply to preliminary issues relating to the validity of wills or other acts by virtue of which assets are transferred to the trustee. So Article 4 is looking at what I called Phase 1, the placing of assets under control of a trustee. Now, the wording does not exactly track the wording of Article 2. Obviously, I have to accept that. But I say that in the scheme of the Convention as a whole, it is clear that questions such as whether the trustee or settlor, let's say settlor, has the ability to create the equitable interest which he seeks to put into a trust, falls squarely within Article 4. Now, Articles 6 and 7 are dealing with the applicable law, and by Article 8, the law specified by Article 6 or 7 shall govern the validity of the trust, its construction, its effects, and the administration of the trust. And then they've set out a list of particular matters that the applicable law is to govern. And one question which your lordships will have to reflect on is what is meant by the word its effects.
How do you square the reference in Article 8 to validity of the trust to what you've just said about Article 4?
Because you have the steps, the preliminary acts needed to bring the trust into existence. But once it's been brought into existence, its validity may be challenged under its own proper law.
So you say it's like a double rule, like the old
Yeah,
yes.
yes.
It has to be valid under the
Yes.
law of the place and under the law of the under the proper law.
Yes. Well, I think I put it more as a matter that proceeds in stages. You first of all got to get the placing of assets into a trust, and that brings in the lex situs, because you're dealing with the question of the ability to create proprietary interest in assets. Once you've got over that hoop, you then have to get over the validity test in Article 8. I say the validity test. You may face a validity challenge under Article 8, but that's under the trust law, the bottle law of the trust. Now, Chapter 3 of the Convention is dealing with recognition. A trust created in accordance with the law specified by the preceding chapter shall be recognised as a trust. Such recognition shall imply as a minimum that the trust property constitutes a separate fund, that the trustee may sue and be sued in his capacity as trustee, and that he may appear or act in this capacity before a notary or any person acting in an official capacity. Just put in there, paragraph 2 of Article 11 is a direct reflection of Article 2A. And again, there is no mention whatsoever of recognition implying as a minimum that the beneficiary acquires an equitable proprietary interest.
I didn't hear that.
It does not say that it's a minimum requirement that the beneficiary must acquire an equitable proprietary interest. And the third paragraph of Article 11 rather spells out the consequences of the second. Insofar as the law applicable to the trust requires or provides, such recognition shall imply in particular, A, that personal creditors of the trustee shall have no recourse against the trust assets, B, that the trust assets shall not form part of the trustee's estate upon his insolvency or bankruptcy, then C is dealing with matrimonial property, and D, that the trust assets may be recovered when the trustee in breach of trust has mingled trust assets with his own property or has alienated trust assets. However, the rights and obligations of any third-party holder of assets shall remain subject to the law determined by the choice of law rules of the forum. Now, the final words that I've just read, they were inserted to address the concerns of the Bank for International Settlements, that the provision for recovery of trust assets alienated in breach of trust might affect the system of real rights in force in the country where the assets were situate. And if I can give you a reference where you'll find the memorandum from the Bank for International Settlements, it's volume Authorities 2, tab 11, MS 1481 to 1482.
That would only matter where the country where the assets were situate was a party to the convention, wouldn't it?
Yes. Yes. As if you're not parties, yes. Yeah.
Yep. Yep.
So you submit that D is consistent with there being no obligation on convention states to recognise a proprietary interest of a beneficiary.
Yes. Perhaps I could show you a paragraph in the von Overbeck report, since this has been raised. It's Authorities Volume Tab 3, para 113 at MS 1041.
Thank you. Yep.
Sorry, I've got the wrong volume.
Authorities Volume 1, Tab 3, MS 1041.
Yep.
Subparagraph D of the third paragraph deals with tracing, which is a right that the legal systems which have trusts grant the trust beneficiary when the trustee has violated his obligation by mingling trust assets with his own property or by alienating such assets. The second sentence specifies, although this might go without saying, that the relations of the trustee and the beneficiary with any third party who holds trust assets are not governed by the law applicable to the trust, but rather by the law designated by the forum's choice of law rules. This provision concerns, for example, the relations between a trustee and a bank in a country which does not have trusts. Such a bank will therefore not incur the liability, which is, to tell the truth, rather limited, that the law applicable to the trust may impose on banks in case of a trust's breach of his obligation. So again, this
even
is a
with
point
notice.
at which we move outside the convention.
But this is a recognition case because we're talking about potential Cayman Islands trust.
Yes.
So what are the relevant choice of law rules of the forum? Are they the rules relating to property or relating to trusts?
Well, in this case, the forum is England.
Yes.
And it's law relating to property, because you moved out of the law governing the trust.
Well, you may have moved out of the law of governing the trust under the convention, but you're still referred to the choice of law rules of the forum, which may include the choice of law rules for trusts. So it begs the question, doesn't it?
Well, yes. I mean, we haven't reached that point yet in this litigation. Yes. I think this may become clearer when I get to Macmillan, but just going back to the last sentence of 11D. If we got to the last sentence, the rights and obligations of any third-party holder of the assets shall remain subject to the law determined by the choice of law rules of the forum. Now, in England, the choice of law rules of the forum, when one characterises the question as being what property rights do we have in the shares and what property rights does Sickle have in the shares, and we say that the effect of Macmillan and other cases is that that is governed by the lex situs. So at that point, you move out of the trust and into Saudi Arabian law.
But that assumes that obligations means property obligations.
Yes.
Can I just clarify one thing? My friend said that the issue is what property rights do we, by that he means Samba, and what property rights does Sickle have? We haven't, where he's right is we haven't got to the stage in the litigation of what property rights do Samba have. At the moment, the litigation is entirely focused on the prior question as to whether Sickle has any rights, because that's the attack. At a later stage, if we get there, when and if we do, and they seek validation, then the question would arise as to what rights, if any, Sickle got. But we haven't got to that stage of the inquiry yet.
Now, finally, there's Article 15 of the Convention. And I've already shown you that by Section 1.3 of the Act, Article 15 is in effect made mandatory, the Convention does not prevent the applications of provisions of the law designated by the conflicts rule of the Forum, insofar as those provisions cannot be derogated from by voluntary act, relating in particular to the following matters. And then I rely on D, the transfer of title to property and security interests in property. If recognition of a trust is prevented by application of the preceding paragraph, the court shall try to give effect to the objects of the trust by other means.
So can I just ask, the conflict rules of the Forum, which is England,
Yes.
does that means the conflict of law rules of the Forum other than the rules in the Convention, does it?
Yes, because the words the law in Article 15 are defined in Article 17. In the Convention, the word law means the rules of law in force in a state.
No, that's a different point.
sorry.
That's a reference to the law which is designated. I was asking, what are the conflict rules of the Forum to which Article 15 refers, which here, because this is a recognition case, what are the relevant rules of the conflict of laws so far as this case is concerned in relation to Article 15? Are they the common law rules, which I think they must be, or are they rules including the Convention?
Well, I think they must be common law rules.
Yes.
So, I am driven back again and again to Macmillan, because that is our common law rule, that title to property, including shares, is governed by the lex situs. Now, just pulling the threads together, if I may do at this stage, states worldwide can broadly speaking, be classified in a threefold classification. There's first common law states, under which the beneficiary of a trust receives an equitable proprietary interest in the trust assets. Secondly, there are non-trust states which do not recognise trusts in any form at all.
Yeah.
Third, there are non-common law trust states. And these are states which recognise trusts as having the minimum attributes in Articles 2 and 11 of the Convention, but which do not recognise a trust as creating an equitable beneficial interest, for the almost universal reason that in the jurisdictions in question, there is simply no concept of splitting ownership rights between legal and beneficial.
Yeah.
And I think that category of non-common law trust states is very largely overlooked by Sickle in its case. Now, I want to just say a little bit more about this because it's rather important to understanding the way the Convention was framed. Could I first of all take you to Underhill and Hayton, current edition 2016, that's AV9, tab 101, MS 3886.
Yep.
Now, in Article 10, headed "What property is capable of being made the subject of a trust?"
Yep.
Propositions 1 and 2 are trite for us.
Yes.
But Proposition 3, for other foreign states ownable under the lex situs and located in jurisdictions that have implemented the Hague Trust Convention, the trust will be treated as creating a specially preferred obligation against the trustee, so that the beneficiary's collective interest in the trust patrimony has priority of the trustee's creditors, spouse and heirs, who can only look to the trustee's private patrimony for satisfaction of their claims, except where favoured by some local mandatory non-trust law under Article 15, 16 and 18 of the Convention. And then the author elaborates that further into the text at 3889. Sorry, 3899, the effect of the Convention in non-trust states.
Sorry, 389.
99, sorry, my fault.
3889.
99.
3899.
Sorry.
The effect of the Convention in non-trust states, paragraph 100.46, the Convention does not introduce the common law trust with equitable proprietary rights of trust beneficiaries into the domestic law of states which do not have such trust concept, but have a closed list of property interests, numerus clausus, and a concept of unitary ownership of property. It requires those ratifying or exceeding states to recognise trusts falling within the Convention scope for private international law purposes only. This does, however, require such states to recognise a diluted trust concept of a segregated ring-fenced fund or fiduciary patrimony immune from the claims of the owners, creditors and heirs. Indeed, various states already have a concept of a ring-fenced pool of assets separate from the owner's private patrimony, where there is a fund dedicated to achieving a particular purpose, and property substituted for dedicated purpose is dedicated to the same purpose as a property by a process of proprietary subrogation. Article 2, paragraph 2a, and the second sentence of Article 11 make it clear that the trust assets constitute a separate fiduciary fund and are not to be treated as part of the owner's private patrimony available for his personal creditors and his heirs. Quote, this is an essential element of a trust, without which recognition would have no meaning, as stated in paragraph 108 of the Van Overbeck report on the Convention, and emphasised by paragraphs A, B and C of the third sentence of Article 11.
And do you accept that that type of recognition of a segregated ring-fence fund is something which is within, well, is the same as what they're talking about in Article 11, and is something which doesn't depend upon the lex situs? It's something which can simply be treated as recognised by Cayman or English law.
Yes.
Right? So why isn't that a form of property within Article 127?
Well, because it's
patrimony. If you dispose of a separate patrimony, which is not part of your private patrimony, why aren't you disposing of property?
Well, because the fundamental difference between fiduciary patrimony and property is in the latter you do acquire a property interest, whereas in the former you don't. You require personal right against the trustee, but it's good against the trustee's creditors.
It's a form of agency.
Yes, I see.
Could I ask,
Yeah, well, yes.
Rather loosely, but
why is this paragraph relevant? Because as the heading shows, and quite a lot of discussion shows, it's about the effect of the Convention in such states. How does it help us in relation to the effect of the Convention in a trust state?
Well, it helps because one can't look at the Convention through purely English eyes, if I can put it in that way. One's got to start from the position that the Convention is accommodating the position of common law trust states and non-common law trust states. And that is essential to understanding its objectives and its drafting.
If you were to trying to get one proposition out of this paragraph, what would it be?
Well, it would be that that fiduciary patrimony is an inroad into the concept of unitary ownership of property, and that is a concept which the Convention seeks to enable to be recognised without those countries which don't have common law trusts being forced to recognise equitable proprietary interests which don't exist under their system. I mean, one has, in this case, one has got to keep standing back and ask, what is Sickle trying to do? Sickle is seeking to establish an equitable property interest in a species of property whose ownership cannot be divided by Saudi Arabian law. And we say that all this is relevant because it shows that the Convention accommodates civil law jurisdictions who don't recognise equitable proprietary interests by bringing in the concept of fiduciary patrimony. I mean, it's put in, I won't read the whole of this paragraph, but towards the end, can I just pick it up about 10 lines from the end, a sentence starting, "It is crucial," at page 3900. "It is crucial that the beneficiaries can claim against the trustee and his creditors and heirs that the relevant fraction of the mingled asset or the whole substituted asset purchased with the proceeds of sale of a trust asset are held as part of the trustee's fiduciary property for their exclusive benefit. If, however, the trustee had simply made a gift of a trust asset to X, then X would take free from any claims of the beneficiaries upon obtaining a good title under the lex citus governing the validity of the gift. In a nutshell, the beneficiaries have no proprietary in rem claim that can bind the transferee X. And that's the common law position, that they would have such a claim. But they do have an in personam ad rem preferential personal claim against a trustee owner that affects the trustee's own private creditors and his heirs and any divorcing spouse."
Can I just go, I hope I'm going to be forgiven for this by the President, but can I just go back to Mr. Howard's intervention? Do I understand it to mean that this appeal is only concerned with relations between Sickle and Mr. Al-Sanir?
Well, I mean, we are concerned with relations between Mr. Al-Sanir and Sickle because we say that Sickle didn't acquire proprietary interests. So, I mean, we're not exactly unconcerned with the result, but that is the first stage of the inquiry.
It is the only stage in this litigation. It's actually very important to not lose sight of that. That's the battle that Samba have taken. They said simply that Sickle could not make its claim under Section 127 of the Insolvency Act because Sickle, put it very simply, never had any interest which could amount to an equitable proprietary interest. And so the claim gets cut off at that level. If they're wrong about that, no doubt there are other issues that would arise as to the circumstances in which they acquired the shares, but we have not got to that stage. It hasn't even been addressed in evidence at the moment.
Because it wasn't the company's property, is that the point? Yes. Under Section 127?
Yes.
In what other context would it be relevant whether this property was Sickle's property? I suppose it would be relevant if there was some dealing with the property. well, if there was any dealing with the shares by Mr. Al-Sanir, the same question could arise, could it or not? Or would it always be then sufficient to look at the in personam position?
Yes. I mean, from our point of view, we're the registered owner of the shares on Tatterwall.
Yes.
Now, obviously, at the moment, in a sense, they're frozen. We can't deal with them whilst we're facing Sickles' claim.
But as between Sickle and Mr. Al-Sanir, why isn't this an interest arising out of property, as between them?
Well, because
Within the definition of Section 436.
well, because there isn't any property, anything to arise out of.
Well, there is the property are the shares under English law and Cayman law, as between Sickle and Mr. Al-Sanir. There is an interest, isn't it, arising out of
No,
the property.
but the property, which is a subject matter of the Section 127 claim, is the sale,
Shares, the actual
of the
shares,
shares from Mr. Al-Sanir to Samba. So that's what has to be impugned. And so the only relevant...
Property is the shares, yeah.
Is the shares.
Yes.
And your case amounts to this, that you can't have under Cayman law or under English law, a property interest in shares unless the lex situs allows you to.
Exactly.
Yeah.
I mean, in a sense, that's what the case is about. It's
Yeah, it's the
very-
beginning and the end of the case. Isn't
Yes.
it? We have one or two further points on the
Yes.
convention, but that's really the issue now.
Yeah.
Well, the fundamental issue. Mm.
Now, can I, before leaving this particular aspect of it, can I do two things? First of all, I want to go to Van Overbeck Report, Authorities, Volume 1, tab 3. This is
Yep.
MS 1021,
Yep. Yes.
paragraph 26.
Thank you.
I'm not going to read it out, but towards the bottom of the page, the right-hand column, you'll see all sorts of countries which believe they already had a trust in the Article 2 sense before signing up to the convention. And in our Annex 2 to our case, if I may just remind you of this very briefly. At Core Volume 1, MS page 120,
Yep.
we give a sort of a mini survey there of trusts in non-common law jurisdictions.
Oh, yes.
And you've got the mixed, in a sense, the mixed systems such as Scotland and South Africa, where their system of law uses the word trust. But as you can see from the citations on page MS 120, I just take the second of them. In Scotland, by contrast, the concept of equitable interest has never been recognised. The interest of the beneficiary under a trust is regarded as purely personal in nature, although on the insolvency of the trustee, the trust property is protected for the beneficiaries of the trust. And then, having reviewed the position in South Africa, we look at those countries which have amended their law, because obviously ratifying the convention is one thing, but if you don't have in your domestic law the ability to create an Article 2 trust, then you've got to amend your law to facilitate that happening. And that's what happened in Switzerland and the Netherlands. In Italy, that was done through judicial development. And we end up this annex at A2.27 MS128 by addressing what we regard as an inter oram submission from Sickle. They say that if we're right in our submissions, the effect on trust interest will be dramatic and destabilising throughout the world.
Yes.
That's their case at para 122. And that no trust of common law situated assets could possibly justify acquiring assets situated in a non-trust state. That's their case, para 130. And we say this is just a gross exaggeration because it entirely overlooks the large number of non-common law trust states, all of which are civil jurisdictions. Second, it's axiomatic that if you purport to acquire an equitable interest over an asset in a non-trust state, you're not going to acquire an equitable interest. And that shouldn't come as a surprise to anyone. And finally, from a practical perspective, in the real world, trusts, commercial trusts, make their investments through specially formed investment vehicles. They own the assets, and there's no division of interest at that level, and the trust is over the shares of the investment company, which is why this has never, why this has not previously emerged as a problem. And look at this from the other end of the spectrum. Can I take you back to our case at CV1 MS82? I'm not going to go through these paragraphs. I've really largely made these points, but in paragraphs 14, 15, 16 and 17, we set out the very adverse consequences that would follow if Sickle's case were to be accepted, that you can interfere with the property laws of a non-trust state. Now, may I move on now to the question of lex citus? And this, as you'll also be aware, this comes into our argument really at stage 1.
Yeah.
Could we start with Macmillan in the Court of Appeal? Authorities, Volume 1, Tab 7, MS 1180.
1180.
1180.
Thank you. Yep.
Now, facts are very well known. Lord Justice Staunton begins his judgment at MS 1184. at 1192, he considers the appropriate conflict law, 1, for property issues in general, and he first reviews the law relating to land, and then the law relating to chattels, and then over the page at 1193, the law relating to shows in action, and then at 1195, he comes on to a heading 2, shares in particular, and there's a long discussion of Colonial Bank and Cady and Williams, and he summarises what is to be drawn from that decision at page 1197.
Yeah.
Being up at letter D, 4 points are clear from that decision. First, there's a dual conflict rule which allocates some issues to one country and others to another. Secondly, the issue in Cady's case was as to who was entitled to the certificates, not as negotiable instruments, but as pieces of paper. Third, that issue was decided by English law since the transaction took place here, or per Lord Watson, the parties to it were domiciled here. Fourthly, any issue as to the effect of the possession of the certificates or as to how shares could be transferred should be decided by the law of the company's domicile, or it would seem its place of incorporation. So that was a decision of the House of Lords establishing that fourth proposition. And then he applies that to the facts of the case and applies the Lex Citus rule. Lord Justice Auld begins at page 1198.
Yeah.
Yes, I should have read it just on page 1197. I should have read it G, last sentence. The issue is whether, in the words of Lord Bramwell and Lord Herschel, there has been an act effectual by New York law to transfer the property and the shares. That's because the Burlet shares were registered in New York.
Yes. Yep.
And then Lord Justice Auld, starting at page 1198,
Yep.
and I pick it up at letter F. As to the claim, Macmillan says it's based on obligation, not property.
Sorry, letter
describes-
F of which page?
Right, 1199.
Yep.
It describes it as a restitutionary claim, albeit based on its equitable property in the shares. The banks say that it is a proprietary claim, not one arising out of an obligation, since there was no contract or equity between the parties. Mr. Justice Millett, while accepting Macmillan's description of the claim as restitutionary, held that it was the issue that mattered and that it was one of priority of property rights. He held at 994, etc., that that issue is governed by the lex loci actus, which he described as the law of the place where the transaction took place, on which the latter assignee relies for priority over the claim of the original owner, namely New York, where the transfers took place.
Yeah.
So that was Mr. Justice Millett.
Yeah.
He didn't agree with that. At page 409, MS 1202,
Yep.
letter between B and C. Before I turn to those rules, I should consider the alternative argument of Macmillan that the lex loci actus should govern the matter, namely the law of England, because that is where the transaction took place. As I've said, on Macmillan's approach, the transaction was the lending and security arrangements made in London, part of which involved the transfer of the shares in New York, the banks deriving the benefit through the documentation in London to secure their title to the shares elsewhere, London was also where the banks received such notice as they did of Macmillan's interest. For the banks, the transaction was solely the transfer of shares immediately or ultimately in New York. And then page 1204, MS 1204, between letters D and E, in my view, there is authority and much to be said for treating issues of priority of ownership of shares in a corporation according to the lex situs of those shares. That will normally be the country where the register is kept, usually, not always, the country of incorporation. I think that's probably the clearest statement of what we say is the common law rule. And then finally, over the page, he states his conclusion at MS 1205, report page 412, between letters B and C. I therefore conclude that the shares are in the same position as chattels, and that the dispute as to the priority of ownership of them should be determined by the law of New York as a lex situs.
Yep.
Oh, I see.
Did Lord Justice Aldous express a view on the point? Third call. Oh, very good call.
Yeah, yeah. Yeah. Lord Justice Aldous' judgment starts at MS.
Yeah, did just briefly, did he express a view out of interest? I mean, it doesn't matter
Yeah.
if there's nothing to say, but okay.
Mm-hmm. Yes, I think his conclusion is at MS 1217.
Thank you.
I think there's a helpful passage here. Between F and G, as a matter of principle, I believe the appropriate law to decide questions of title to property such as shares is the lex situs,
Right.
which same as law of incorporation.
Thank you.
What was that? And just going back to law,
So there's a
just
slight difference. Some say
Yeah.
where the register is, and some say where place of incorporation.
yes, I
Yes.
think that those differences don't matter here.
Be nice
Yes,
to have
I should have pointed out Lord Justice Stoughton at page 1198. His conclusion is between letters B and C. I conclude that an issue as to who has title to shares in a company should be decided by the law of the place where the shares are situated, lex situs.
And he says incorporated, or arguably where the share register is kept,
Yes,
but not necessary to decide. Great. Again, thank you.
yes, and not necessary to decide in this case.
Yeah.
because-
No, I understand.
One of the benefits of that rule, as the judgments make clear, is that it is conducive to certainty. It's a simple test which you can apply without difficulty. And just to take the present case, Sickle knew that Mr. Alcinair was a registered owner of the shares. It knew it could not become the registered owner of the shares. That's recited in the second share sale agreement. And it took its risk by leaving Mr. Alcinair in ownership as a registered owner. Now, I don't want to spend very much longer on this point because I think it's so well established in English law.
Right.
Can I go very briefly to Glencore Authorities Vol 1, Tab 5, MS 1086.
Yep.
And this is where the question of competing, there was competing title to oil situated in Fujairah. And at paragraph 28 at MS 1099,
Yep.
both the authorities and the commentators therefore clearly support the adoption of the lex citus rule as a rule of general application. However, in the absence of direct authority, I think it right to examine the basis of the rule and to consider whether, as a matter of principle, Mr. Schaff is right in saying that there are grounds for adopting a proper law rule in cases which concern only the immediate parties to the transaction. The lex citus rule has been justified on two main grounds. The first is that it accords with the natural expectations of reasonable men and facilitates business, and he cites Mr. Justice Morn. And then going down to paragraph 29, the second main ground is it reflects the practical realities of control of movables. So that's another strong endorsement, and he concludes at paragraph 32, MS 1100. These considerations, together with the practical considerations of trade and commerce, provide strong support, in my view, for the adoption of a lex citus rule in all cases.
Why does it, in the case of shares, reflect the practical realities of control? Because presumably Saudi Arabian courts would recognize a foreign judgment, for example, that the shares have been sold, and they would give effect to that on the register. A foreign judgment relating to the ownership of shares would presumably be given effect in Saudi Arabia. It's not that movables are in a particular place, but the share certificates are intangible, or shares are intangibles.
Yes. Well, I'm very reluctant to...
Yes, anyway, you say that's a factor.
Yes. And then, lastly, there's Stichten Shell Pension Funds Authorities, Volume 1, Tab 10, MS 1245. In paragraph 15 of the judgment at page 1255, this is a judgment of Lord Sumption and Towson in the Privy Council. Paragraph 15, line 4, the lex citus is of course relevant to the question what assets are truly part of the insolvent estate. It will generally determine whether the company had at the relevant time a proprietary interest in an asset, and if so, what kind of interest. So there's a pretty formidable body of case law at the highest levels favouring the lex citus rule for determining property ownership in shares.
Are you, not necessarily in the present context, going to deal at some stage with Mr. Justice Millett's judgment in El Adju?
I wasn't going to, no.
Right.
Can I perhaps think about that over the short adjournment?
We can stop here. Yes.
Now, going back to our case, and I'm going to come on to Article 4 very shortly. Can I just identify certain of the travel that we referred to? First of all, the Overvet Report, paragraph 14. MS 1019.
Yep. Where do we look?
Paragraph 14, the member states of the conference can be divided into two groups, those which have trusts or analogous institutions and those which do not have them. The interest of the part of the one group and the other for ratification of the convention is consequently not identical. The states which have trusts, the principal interest is obviously to have the trust created under their laws recognised in the countries which do not have this institution, etc. Then go down to the next paragraph. The interests of states which do not have trusts appear less clearly. These may, on the contrary, fear that the principles of their judicial systems might be shaken by the inclusion of a somewhat troubling foreign institution. In this connection, it should be emphasised there was never any question of introducing the trust into civil law countries, but simply of furnishing their judges the instruments which are appropriate to grasp this legal device. Now, I rely on that because it shows that the convention was not there to pose a threat to civil law countries. It was facilitative. And it should certainly not be interpreted, as the Court of Appeal did in this case, in a way which creates and forces upon Saudi Arabia equitable interests unknown in that state.
But the context of that is recognition by such states.
It is, but it's a theme of the whole convention. Respect for the rights of civil law countries. Next, in the Travo, there's AV Volume 2, page MS 1499. And this is, in the left-hand column, le rapporteur is speaking in French. Now, we've got a translation of that. There's a very slim Authorities, Volume 2, complete tab 12, and this is MS 1687B.
One. What? Sorry.
1687B.
Thank you so much.
Don't you? Have they got it?
I don't think I have this, but I'm not troubled by following it in French.
Is this a translation of von Overbeck's, of Professor
Yes.
von Overbeck's observations? Yeah, I see.
I don't know if you can read it in the French. Can I?
Is this page 1499? Are we looking at the chunk in
1499, left-hand column,
In the middle.
rapporteur rappel.
Okay.
I don't think I have it.
Oh, it might be at 1686, I'm told, MS 1686.
Is that the same bundle? No.
Yep.
Oh, yes, I see, yes, it's in twice. Thank you, yes, 1686.
Thank you.
Yes. Thank you.
The rapporteur recalled that the object of the Convention is to give civil law jurists an instrument enabling them to grasp the notion of this strange legal institution, which is a trust. There is no intention of introducing the trust into civil law countries. The question was discussed for Swiss law, but it was decided against. The introduction of the trust would disrupt the entire system of legal rights. Anything else is a task of private international law, which can lead to the application of a foreign law. The additional difficulty here being the fact that the institution does not exist in civil law countries. But it's clear there will always be the domain of the application of trust law on the one hand, while on the other there is the field of application of the institutions of common law countries regarding real rights, inheritance rights, and matrimonial regimes. To the extent that the law applicable to such institutions is mandatory, its provisions must be maintained and cannot be interfered with by the intervention of a trust. The work of this Commission will doubtlessly be to clarify the uncertainties which may remain in this field. One must not, however, have too many illusions. There will always be room for interpretation without going into the details, which would risk becoming too specific and in turn evading interpretation.
I mean anything you wanted to mean. Sort of. Two parties to a contract who don't want to spell out what they've actually decided.
Again, it's all in the context of recognition.
Well, it's actually really all in the context of consequence.
Well, I was thinking of the first sentence.
Well, yes, I agree the first sentence is orientated towards recognition. But when the rapporteur speaks of not disrupting the entire system of real rights, he's looking at the consequences of enforcing equitable interests on common law countries, civil law countries. Now, I now want to come on to Article 4. The issue here, as the Court of Appeal said, is where does Article 4 draw the cut-off line? I accept that. And can I show you the views of Professor von Overbeck in A2, tab 11, MS 1501.
Yeah. 1501. Yep.
Yes. Have we got that translated, Helen? Right. I got it. This is in French. I think the translation, I think, is on its way up.
1501.
Yes, 1501, left-hand column.
What is the section, le rapporteur estime, is it?
Yes.
Le rapporteur estime.
Estime au contraire. Mhm.
The reporter considers, on the other hand, that it's not necessary to report such a hypothesis. In Anglo-American doctrine,
Thank you very much.
Yes.
Well, this doesn't look very helpful to your case, does it? That Article 4 is talking about a situation where a holder declares himself trustee. Seems to be talking about capacity and about previous transactions by which the holder acquires the property.
well, if we look at the next contribution from Mr. Hayton on the same page, 1501, Mr. Hayton set out as an example, a national of a civil law country, for example France, purports to create a trust and names English law as the applicable law. Clearly, English law cannot be used to decide whether he is able to create a trust. That is a matter which must be left to French law. It's for the local law to decide whether he has the capacity to state that he is a trustee. In this proposal, we are saying that creation of a trust, that is, matters of formality, capacity, etc., are questions which will be excluded from the Convention and be dealt with by the local laws. All other matters are covered by the Convention.
That doesn't exactly correspond to the language of Article 4, does it? I mean, obviously, lack of capacity is one reason why a transfer to the alleged
Yes.
trustee might be ineffective.
Yes, well, I say
It's not confined to that by any
no, it's not, no.
But how much value are discussions which don't lead to any form of an agreed minute?
I'm sorry.
How valuable are these discussions which don't lead to the conclusion
Well-
of an agreed minute in interpretation of the Convention?
Well, I accept that von Overbeck is a stronger source of Travo, and he obviously refers to these discussions and brings them together. But I think it is helpful to look at some of the background.
Lord Collins' points perhaps reinforced when you read Mr. Lysar's intervention on the right-hand column, where he was expressing some doubt as to what exactly they were arguing about.
Yes.
Yes, these don't look like bullseyes, which is the test, isn't it?
I'm sorry.
Isn't the test whether they are a bullseye, in other words?
Yes, I think that was Lord
they
Staines'
don't.
test, yes.
Yes, they don't look.
Pretty bloodshot bullseye. Yeah. Well, we're not going to get the answer going forward.
And finally, can I show you an article by Professor Hayton,
Yeah.
A8, tab 87.
Page.
3505.
Thank you. Yep.
Towards the bottom of the page.
Thank you.
So far as concerns the inviolability of
Which
the
page are you
trust
on?
fund,
3505.
3505.
Yeah.
So far as concerns the inviolability of the trust fund, the obvious problem, as made clear at the outset by Georges Droz and the delegates from non-trust states, is that the Private International Law Convention could not possibly introduce a trust concept into the domestic law of non-trust states, nor create any new proprietary rights in such states, whether openly calling them equitable rights or just special rights. This underlies Articles 4, 11, 3D, 12 and 13.
Is that the question? It's not being suggested that Saudi Arabian law has been altered. It's been suggested that English and Cayman Island law should recognise these transactions as giving rise to proprietary rights.
Well, that would be to alter Saudi law.
It would simply be to say that in the eyes of jurisdictions which subscribe to the convention, there is a proprietary right, and they would then enforce it as best they can, and if that led to orders for return of the assets, no doubt those would be enforceable as in personam orders in Saudi Arabia.
There is actually never going to be an attempt to enforce in Saudi Arabia. That's in fact common ground for various reasons that the Saudi courts simply would not recognise. So any enforcement is actually against Samba, who are in this jurisdiction, to make restitution or something similar.
But that's gives rise to the same point. I mean, I agree that this proposition I was putting to you does lead to a conclusion that you have something which is recognised as a proprietary right in convention countries, which is not recognised in the place of the lex situs, but may not matter. And maybe that's what the convention does.
Well, it's theoretically possible, don't disagree with that, but I say that if you were to treat sickle as having an equitable proprietary interest, you would be interfering with the laws of Saudi Arabia.
Again, the whole of this context is recognition. It's all about Article 7. It may be, I think, possibly, your argument can be, if you look to the opposite page, you would adopt what Professor Schönblum says in the first sentence.
Yes, I haven't got it still open, I'm afraid. Yes. Yes, well, I think that's a fair comment. Now,
When was this article written?
1996. Now, if I'm right so far, the only question is, does it make any difference that we're dealing with a declaration of trust and not a settlement? And I say there's no material difference between the two for present purposes. The first point is that any such distinction would be unprincipled, because both processes are covered by the Article 2 concept of placing assets under the control of a trustee for the benefit of a beneficiary. It's true that with a declaration of trust, assets are not placed under the control of the trustee in the sense of his acquiring a legal title, but he notionally transfers assets from himself beneficially to himself as trustee. Secondly, I say that any doubt about this is resolved by the travaux. Now, can we start with Professor Oberbeck's report, AV1 tab 3, MS 1028.
Yep.
And it's paragraph 57 in the right-hand column. The words assets or transfers to the trustee are completely clear when the settlor and the trustees are distinct persons, In contrast, one may doubt whether they cover the case of the declaration of trust in which the two persons are mingled. The owner of the assets declares that henceforth he will hold these assets as trustee. The Commission unanimously accepted that the acts which were held or was effectuated must also be envisaged by Article 4 and therefore excluded from the Convention's scope. A proposal was offered to express this by the words acts by which assets are placed under the control of the trustee for trust purposes. The 15th session, after having accepted this proposal, returned, however, in the end to the terms used in Article 2 of the preliminary draft. It was on the one hand that this expressed rather clearly the idea that Article 4 also applied to the declaration of trust, and on the other hand, if it was not desired to take it up here the allusion to control, which appears in a different perspective in Article 2, first paragraph. A proposal to make express allusion to declaration of trust was offered on the second reading, but would not receive the absolute majority required to order that the discussion be reopened.
Lord, one of Mr. Hapgood said to me that he's feeling rather faint at this moment, and he's asked if I would just take over on this point.
Yes, would he like 5 minutes anyway?
Would you like?
Yeah. Would that be a good idea? We'll rise for 5 minutes. Very much. Court's now adjourned.
Lords, very, very grateful for that. If your Lordships will permit, I will deal with the paragraph 57 Van Overbeck report on behalf of Mr. Hapgood, and then he'd like to carry on.
Well, as far as we're concerned, the most important thing is people's health, and if Mr. Hapgood is feeling not up to addressing us at the moment, then certainly you should do so. And if at any time wish to leave court or anything, please feel free. And if he feels like addressing us, we'll be very pleased to hear from him. Mm-hmm. But we take a practical and proceed as you and he wish.
Very good, very good, very good, my Lord. Well, if I can just try your patience then a little on this. If we could go back to paragraph 57 of Van Overbeck. Your Lordships have seen what is said there at page 1028. And if we may just go through paragraph 57 again. The words assets or transfers to the trustee are completely clear when the settlor and the trustee are distinct persons. In contrast, one may doubt whether they cover the case of the declaration of trust in which these two persons are mingled. The owner of assets declares that henceforth he will hold these assets as a trustee. The Commission unanimously accepted that the acts by which this change in the capacity in which the assets were held was effectuated must also be envisaged by Article 4 and therefore excluded from the Convention's scope. Now, I'm going to show your Lordships how exactly that occurred. A proposal was offered to express this by the words acts by which assets are placed under the control of the trustee for trust purposes. So the proposal was to express this by importing the language of Article 2 into Article 4. Your Lordships will recall that Article 2, in defining a trust, pivots around the concept of assets being placed under the control of a trustee. That's page 984.
984.
984.
Thank you.
So the proposal designed to clarify the intention that the declaration of trust should be included it was suggested it would be implemented by importing the words of Article 2 placed under the control of a trustee into Article 4. The 15th session, after having accepted this proposal, and as we'll see, it did so by 23 votes to 3, returned, however, in the end to the terms used in Article 2 of the preliminary draft. That's in the preliminary draft of this Article 4. It was thought, on the one hand, that this expressed rather clearly the idea that Article 4 also applied to the Declaration of Trust. So it was thought that in returning to the words that ultimately are contained in Article 4, one was returning to wording which incorporated the Declaration of Trust concept. And on the other hand, it was not desired to take up here the allusion to control, which appears in a different perspective in Article 2. So because the word control is used in a particular way, the word control is used in a particular way.
Where are you now reading, precisely?
I'm sorry?
Are you reading now?
No, I'm commenting.
You're commenting.
I'm sorry.
No.
Yep.
Reading with feeling.
Yes.
As opposed to tonelessly. Very well, thank you.
A proposal to make express allusion to the Declaration of Trust was offered on the second reading, but did not receive the absolute majority required in order that that discussion be reopened. And it's very important that we see that that was purely a matter of process and a matter of the French delegate saying, for heaven's sake, we've been discussing this for 2 years. It's clear the Declaration of Trust is included. Can we move on? And I'll show you that. We shouldn't just look at paragraph 57 in isolation, though, my lords, because paragraph 53 of the Van Overbeck report at page 1027 is also highly instructive on this point. Paragraph 53 reads, Article 4 deals with the delimitation, which is particularly delicate, of the Convention's scope of application in respect of certain institutions to which resort must be had in order for a trust to spring into life, and which give rise to legal obligations which are distinct from the trust and preliminary to its inception. The image employed was that of the launcher and the rocket, and then a key phrase which appears elsewhere in the travaux. It is always necessary to have a launcher. For example, a will, a gift, or another act with legal effects, an act with legal effects, which then launches the rocket, the trust. The preliminary act with legal effects, the launcher, does not fall under the convention's coverage. It is always necessary to have a launcher. The whole approach of those who framed this convention was that it was always necessary to have a launcher. On the respondent's case, there is no launcher. There is only a rocket. On the respondent's case, the declaration of trust is simply part of the trust, it's part of the rocket. There is no preliminary act. There is no launcher. It's quite clear that there always has to be a launcher in a declaration of trust and in the case of a settlement, and that in paragraph 57 of von Overbeck, it was recognized, the recognition that a declaration of trust was equally subject to Article 4 was based on that same conception. A further point of importance to be derived from these passages is as to the scope of what falls within Article 4. If your lordships will look at paragraph 55 of the von Overbeck report at 1028, paragraph 55 says, Article 4 is intended to exclude from the Convention's scope of application both the substantive validity and the formal validity of the transfers which are preliminary to the creation of the trust. As concerns form, it may be difficult in certain cases to distinguish. However, according to the explanation, and then it goes on, according to the explanation given by the delegates of common law countries, what counts is that the instrument of transfer, the launcher, may be valid as to its form. So that's the common law perception in relation to the formalities requirement.
Mr. Green, what might seem very clear from the second half of paragraph 53 might be thought to be rather less clear when you carry on reading 54.
What passage does your lordship
Well,
have in mind?
it's the transfer of assets is recognised as a sine qua non for the creation of the trust. But the law applies only to the establishment of a trust and not the validity of the act by which the transfer is carried out. So I find it a bit difficult to fit that into the launch pad picture. I mean, on one view, then, the act, which is the sine qua non for the creation of a trust, is a preliminary matter excluded by 4, which is what the other side contend for. But that I appreciate doesn't square readily with 57.
No, my lord, I think that, with respect, I think the point that's been made here, it has to be read all in the context of paragraph 57 and what Article 4 actually refers to. Article 4 refers to a transfer of assets to the trustee. And what's being said at paragraph 57 is that the concept of a transfer of assets to the trustee was intended to incorporate a declaration of trust. So when at paragraph 54 you see references to a transfer of assets, the declaration of trust is within that contemplation. A transfer of assets within the contemplation of Article 4 is a sine qua non of every trust. There has to be something preliminary. There has to be a launcher. Before you can have a trust, there has to be something that brings it into existence. Before you have a trustee, there has to be something that constitutes someone a trustee. That's all that paragraph 54 is saying. It would be surprising if paragraphs 53 through to 60 were saying inconsistent things. And I can only endorse what was being said by my friend Mr. Hapgood, that the von Overbeck report, it is the official explanatory report in relation to the convention. If anything is authoritative in relation to its interpretation, apart from the words on the page, it's the von Overbeck report. And although there's a limit to what one can get from the archaeology which which precedes it. The fact is that archaeology is important in order to understand exactly why what is said at paragraph 57 of the von Overbeck report is not in fact nuanced, it's actually entirely accurate as to what occurred.
Is this a formal authority, this report? I mean, is it referred to in the Convention as a source of guidance as to interpretation?
No, it's not. It's
No,
not.
it's not,
It's the after event exposition.
Now, do I understand the effect of your case to be that if you have a trust which operates in respect of different assets and perhaps has proprietary and non-proprietary aspects, the Article 4 would attach only insofar as you're talking about proprietary aspects of the trust?
So far as is actually relevant to this particular appeal,
Yes, so-
the question is, can you sever legal from equitable title?
Yes. So, I mean, in just taking these particular trusts, all you're submitting is that this can't be recognised as a proprietary trust because of the lex situs of the relevant assets, but it could be presumably, assuming it's subject to to Cayman Island law, it could be recognised as a trust which had all the effects set out in Article 11. In other words, gave rise to a lot of in personam obligations and rights and a split patrimony and so on.
Well, the question would be, my lord, the question would be whether, under the lex situs, the purported dealing with the property created a situation which was capable of meeting the definition of trust under Article 2.
No, but why does the lex situs matter if
there's-
trust is perfectly capable of having all these in personam effects?
Well, there's two ways into this question. That if I'm starting at the beginning, we say that under English conflict of laws rules, you've got to look to the lex situs to see what is permissible as regards the dealing with the property. Now, it may be possible to create equitable proprietary rights, in which case, if you have chosen a Cayman law trust, then no problem. The property in question, you've created equitable proprietary rights in it. It may be that under the lex situs, it's only possible to create fiduciary patrimonial rights.
Yes.
Yeah? But fiduciary patrimonial rights, whether deriving from a civil law jurisdiction having enacted such rights, or Scots law, which recognises, as my learned friend Mr. Hapgood indicated earlier, which has recognised in personam rights under a trust without having any particular civilian issues. If you've got a fiduciary patrimony, which is possible under the lex situs, then transferring property to a Cayman trustee may well create a fiduciary patrimony in that property. You will have created a soft trust, a trust which is capable of recognition as such under Article 2.
Why is the lex situs in the slightest relevant in deciding whether you can create a non-proprietary interest? I don't understand that. Why don't you just look at the proper law of the trust, which is Cayman Islands? Lex situs is only relevant for proprietary purposes. No one has suggested, have they, in the rest of the law, that it's relevant for ordinary contractual or in personam purposes. So why do you look to whether I'm just trying to understand the theoretical position. Why do you look to the lex situs to ask whether you can create non-proprietary interests by a trust?
No, I accept that. That's a fair question. We're limited here to the question of whether a proprietary interest has been established.
But, this passage helps you on Article 4, but destroys you on Article 2, doesn't it? In other words, as far as I understand it, it accepts that declarations of trust come within Article 2, namely where assets...
No, my lord. Oh, this is Article 2 of the preliminary draft. Sorry, I apologise. What are you referring
I'm looking at paragraph 57. The opening words of paragraph 57 of the von Overbeck report.
Yes.
The expression assets or transfers to the trustee are in where?
Article 4.
They're not
No.
in terms there, but so basically he's saying that Article 4 applies to a declaration of trust.
Correct.
But your primary case is that as a result of Article 2, the Convention doesn't apply at all.
No, my Lord. Our primary case is as a result of Article 4. The Convention doesn't apply at all. The possible source of any misunderstanding is that in the preliminary drafts, what became Article 4 was referred to as Article 2. And I'm going to show you that. This is actually quite important insofar as anything background is important here. This is actually quite important. But so our primary case is Article 4. Applies to a declaration of trust. Lex situs governs whether you can correct property rights. Bob's your uncle. That's our case.
I see. So you're not relying on the preliminary point that because Article 2 refers to assets being placed under the control of the trustee, the Convention doesn't apply.
No, we say, as your Lordship will have seen from our case, that we actually regard the concept of assets being placed under the control of a trustee and assets being transferred to the trustee as being a kindred concept that equally applicable to precisely. And the very fact that the Special Commission voted 23-3 in favour of changing the wording of what became Article 4, so as to bring the wording into alignment with the wording with Article 2, shows that they saw it in the same way. And all that happened then was that when it went off to drafting committee, the drafting committee, for whatever reason, thought, well, actually, we think transfer of assets to trustees is an even better way of referring to declarations of trust. So we will stick with that wording. But there's no doubt that declarations of trust are caught by Article 2, even though Article 2, as we say in our case, and I know your Lordship will have, uses the concept of assets having been placed under the control of the trustee. A self-declaration doesn't literally involve assets being placed under the control of a trustee. It involves someone who's already got control saying, I'm a trustee. So we say these are kindred concepts. They're natural bedfellows. There's nothing to be made of the point that the respondents make. Oh, for heaven's sake, they say the language is different. It was obviously intended that these expressions should have different meanings. The fact is, it's clear we say that the concepts are siblings, and furthermore, that the Commission and those who were framing the Convention understood as much. That is our case. Thank you. Now, I was saying to your Lordship that paragraph 55 is important because it shows that substantive and formal validity were included within Article 44, and that this wasn't simply a matter of capacity is further reinforced by paragraph 59, because they actually addressed capacity as a separate consideration. And the von Overbeck report records at paragraph 59 at 1028, concerning Article 4, the question was also discussed as to whether capacity was one of the preliminary questions excluded from the Convention's scope. And then your Lordships see what was said. In the end, the Commission did not expressly exclude general capacity, i.e. can a minor make a trust, although a consensus emerged that this was not to be governed by the Convention, while the specific capacity to become a trustee was to be so governed. So, not hardly surprising, the question of whether a minor can create a trust is a matter outside the Convention. The question of whether you can be a trustee is a matter within the Convention.
Can I just go back for one moment? I'm sorry to be boring on the precise language, but paragraph 57, do I understand you to say that what's referred to there as Article 2 of the preliminary draft is different from Article 2 in the Convention, and that it's different from Article 2, first paragraph, 6 lines further down?
Yes. Article 2 of the preliminary draft was what became Article 4 of the Convention. I'm going to show you that.
So Article 2 of the preliminary draft is not the same as Article 2, first paragraph 6 lines later.
Precisely.
Got it.
So from paragraphs 55 and 59, we see that Article 4 is not of limited purview at all. It's dealing with substantive matters, it's dealing with formal matters, and it's dealing with matters of capacity. And there's no reason for suggesting, as the respondents do in their case, that Article 4, insofar as there was any discussion of declarations of trust or more generally, is focused on matters of formality and capacity only. It's also concerned with the whole spectrum of issues concerned with substantive validity. And when we go back and look at the travaux in a second, which I will do quickly, we'll see that when people were debating substantive validity, they meant essential validity. They were using that concept interchangeably with substantive validity, which, as you will see, is the way in which we put our case. Now, let me show you the travaux very, very quickly. And we can actually see what happened here with a few very short passages. And it's volume 2 of the authorities manual. You'll just be patient with me. And it's paragraph 1405, page 1405, with which one starts.
Yep.
So 1405,
Yep.
early history, 1982, you see a very early draft of the convention, and what is now Article 2 of the convention, the definition of a trust, is there as an Article 2, but there is no equivalent to our Article 4. At the stage of the very early drafting of the convention, there was no preliminary issues article at all. And if we then go to paragraph 14, to page 1409, we see a comment from the Netherlands delegate, which is the origin of this whole provision. Under the heading characterization, during the first special commission, the illuminative image of the rocket and the launcher was used to refer to those situations where the creation of a trust, the rocket, forms part of another act, a contract or a will, the launcher. Whereas the rocket is to be governed by the rules of this convention, the convention would not affect the law applicable to the launcher, which will still be determined by the conflict rules of the forum. It will be helpful, especially for those countries whose law does not provide for trusts, if this idea were in some form or another reflected in the convention. This is the origin of Article 4. And even at this early stage, and it's a feature throughout the travaux, the distinction between the launcher and the rocket is absolutely seminal. It's all very well, with the greatest respect, the Court of Appeal saying they don't find it helpful. But the fact is, it was fundamental to the way in which those who framed the convention have always understood it. If we then flip across to page 1431, please. Paragraph 1431, we're now the 9th of March 1984, and you see that in Article 2, and this is the preliminary version of Article 2, has now entered the Convention. The Convention does not apply to preliminary issues relating to the validity of wills or other instruments, the word instruments was in due course changed to acts, by which assets are transferred to the trustee. And you'll see that the preliminary draft of Article 4 uses the concept of the effect of placing assets under the control of the trustee. So here we have that bivalence between assets transferred to the trustee and the effect of placing assets under the control of the trustee. This is now the context within which the rest of the dialogue can take place.
Thereafter, 2 and 4 got transposed, hence the confusion.
Precisely. We then go through to 1442. And at 1442, we find the exposition of the purpose of Article 2.
Yep.
This provision is one of those intended to solve the difficulty, which is particular to this subject. Trust appears not as an isolated legal institution, but regularly in connection with other institutions. Image of the launcher and the rocket, again, has to be employed. It is always necessary to have a launcher. So, those who were framing this convention, it wasn't just Van Overbeck off on a frolic of his own in the explanatory report in paragraph 53. Those framing the convention approach the matter on the basis it is always necessary to have a launcher. For example, a will, a deed or gift, or another legal instrument, which then sets into motion the rocket, which declares the trust, which is the trust. The transfer of property to the trustee is a conditio sine qua non for the constitution of a trust, but the law designated by the convention applies only to the constitution of the trust itself, not to the validity of the instrument by which the transfer of property is effectuated. The instrument is entirely governed by the law which the conflict of rules of the forum subject it. It can happen, moreover, that different laws apply, and that even it refers to substance, form, and capacity there, not merely.
I think I'm right in saying that the space shuttle first went into space at about this time. I think the Commission may have made an error in adopting the analogy, because personally I find it quite a difficult one.
Well, happily the space shuttle doesn't fall within Article 2's definition of a trust.
Yes, all right.
And so we have it there. And so then to page 1478. And this is where the question of whether a declaration of trust was contained, comprehended by the wording, was actually first raised. It was raised by the Commonwealth Secretariat, and you'll see in the first column at page 1478, under the heading Personal Declarations of Trust, a commentator asking whether declarations of trust are intended to be included within what was then Article 2. And the view was expressed by the Commonwealth Secretariat. It's thought that such cases should fall within the Convention, but the present text is unclear. So the Commonwealth Secretariat was volunteering a view that they reckoned that the Declaration of Trust should fall within the Convention, not outside it. And it says, it repeatedly stresses the transfer of assets, see Article 2, are transferred, Article 4, first paragraph, placing assets is referred to, etc.
And that was Professor McLean.
Yes, early days.
Yes.
Early days, my lord. And then we go to page 1490. So that's the issue having been floated. And at page 1490, we get a proposal in the first column on the 8th of October 1984 from the United Kingdom and the United States delegations, from Professor Hayton and Professor Troutman, I think, to make clear that the Declaration of Trust is actually to be excluded from the Convention. And they suggest, and there's a typo here, the wording of Article 2 should read, the wording of preliminary Article 2, the Convention does not apply to preliminary issues relating to the validity of wills or of acts by which, that should obviously read, assets are placed under the control of a trustee for trust purposes. So obviously they were picking up on the wording of Article 4, draft Article 4. The present Article 2 deals clearly with the case where S creates a trust by transferring assets to trustees. The proposed Article 2 also deals with the case where S creates a trust by declaring himself trustee of specific assets he owns. So the proposal was that by using the language of the definition of a trust, what is now Article 2, what was then preliminary draft Article 4, by using the language of the definition of a trust, which was language which everyone regarded as contemplating a declaration of trust, one would make absolutely clear what was intended, which was that a declaration of trust would be caught by what is now Article 4, but which was then preliminary Article 2. That was the proposal. At 1497, there is a parallel proposal from the Netherlands delegation, bottom of second column, which I'm just going to show you because it puts the following discussion into a little perspective. Proposal of the Netherlands delegation, Article 2, they suggested that it should be expanded, but they included as the dual possibility in square brackets, and then with the there's the dual possibility in square brackets, that the proposal of the UK and the US delegates should have been adopted.
Sorry, where's that on the page?
This is on the second column of
Right at the
1497, proposal number 30 of the Netherlands
Nice.
delegation.
Yeah.
You see? So the Netherlands delegation had their own competing version of Article 2, but that competing version was left open the possibility that the US-UK proposal would be adopted. And then we turn the page to the meeting of the 9th of October 1984, and we note that the Netherlands were in the chair, Mr. Van Berschoten, and that the rapporteur was now Professor van Overbeek. And if we go to page 1500, we see that the chairman, second column of page 1500, towards the top of the page, we see the chairman turn to the discussion of Article 2, and he hands the floor to Mr. Hayton. And Mr. Hayton declared that this convention should not apply to the rocket launcher, the creation of trusts. It's the local law which applies to the rocket launcher. The idea of excluding the aspects relating to the creation of a trust is generally reflected in Article 2, but the article is not wide enough in its operation. Most trusts are created by the transfer of assets from one person, the settlor, to another, the trustee, but the settlor can create a trust by declaring himself a trustee and by declaring that he will hold assets already in his possession on trust for another. Article 2 will exclude the operation of the convention in the first case, but not the second. He pointed out the proposal was intended to exclude the convention in both cases. He said the proposal had been worded in such a way that it will fit in with what's now Article 2, what was then Article 4, thus it should cause no extra problem in drafting. The sole intention of the proposal was to exclude all items dealing with the creation of a trust, either by transference of assets or in cases where the settlor declares himself a trustee. Excuse me. It's recorded that Mr. Bennett, at this stage, towards the bottom of that column, the Australian delegate, agreed that the present draft did not exclude the declaration of a trust. So he agreed that the present draft did not exclude it.
Yeah.
And questioned whether it ought to do so. So the Australian delegate proceeded on the basis that he thought that the present draft actually was wide enough to deal with the declaration of trust, but he questioned whether it should be excluded. He said that the validity of a declaration was not the preliminary issue. Its validity is, in fact, an integral part of the validity of the trust itself. Now, my lords, I'd ask you to underline that expression, because that's the expression which the respondents use at least twice in their case. Mr. Bennett's proposition, which we'll see is resoundingly rejected by the Commission, was that the declaration of trust was not the preliminary issue. Its validity is, in fact, an integral part of the validity of the trust itself. Maybe an accident, but the respondents have used the self-same wording in their case. Why should its validity, therefore, lie outside the convention? That was the question. Then we have Mr. Lowy of Austria, and his intervention relevantly is translated in the sheet that was handed up to you today, which caused the Professor von Overbeek to respond, as it has also been drawn to your attention today. The reporter declares that the article has not, so to speak, been amended. Sorry, I do apologise. Wrong quote. On the fourth quote on the document that was handed to you today. So I should say, if you turn the page in the document.
I see.
Today,
Well,
yes.
the page 238.
Indeed.
1501. Yes.
Indeed.
The rapporteur esteem.
Indeed. So the first of those quotes is from Mr. Lowy, and the second of those quotes is from the rapporteur.
Yes.
The rapporteur considers that it's not necessary to report such a hypothesis. Oh, sorry, you should perhaps read what Mr. Lowy said.
Yes.
Right. And then the chairman called upon Mr. Hayton to comment, and Mr. Hayton says at 1501 in the first column, he set out an example of a national court of a civil law country, for example, France, purports to create a trust, names English law as the applicable law. Clearly, English law cannot be used to decide whether he's able to create a trust. That is a matter which must be left to French law. It is for the local law to decide whether he has the capacity to say that he's a trustee. In this proposal, we're saying that the creation of a trust, that is matters of formality, capacity, etc., and we've seen that it was substantive matters as well, are questions which would be excluded from the convention and be dealt with by the local laws. All other matters are covered by the convention. Mr. Troutman, in the next column, on the difference between the Netherlands proposal and the UK and the US proposal, he realized there was no difference between transfer and place under the control of, because conceptually there is a transfer when there is a declaration of trust. He would still support place under the control of. Firstly, because it reiterated Article 4. Secondly, it would be better understood by civil law countries. Then Mr. Dyer...
Could we see Mr. Gold?
Yes, of course. Mr. Goldwater supported the idea behind the UK and US proposal, but was not certain that the wording in that proposal achieved its end, where the declaration of trust was actually included within that wording. Thus, he suggested removing the passive form of the verb, as the settlor declaring himself to be a trustee was not included within this passive form. If this were clarified, he would support the UK and US proposal. So he too supported the proposal that a declaration of trust should be included. Mr. Dyer said that in his view, the term validity used alone refers to formal and substantive. Well, that is endorsed by the von Overbeck report. The chairman, here we see the slip between substantive validity and essential validity. The chairman said that essential and formal validity of the documents were both included. And then Mr. Bennett continues with a rearguard action on the question of whether a declaration of trust should be a preliminary issue or not. Over the page at 1502, Mr. Troutman. Validity in this context includes both formal and essential validity, and then we have a disquisition on the rule against perpetuities. Mr. Hayton winds up, and the chairman says at the bottom of page 1502, okay, the United Kingdom and the United States proposal might need further drafting. A vote should be taken on the substantive question, and the vote is then taken at the top of 1502, second column. The second vote was on the proposal to substitute place under the control of, and that vote was 23 in favour, 3 against and 1 abstention. And those against were Australia, Mr. Bennett fighting the rearguard action, who had conceded that a declaration of trust was included in the words, but was saying, I don't think it should be. It included France, and we've given you the quotation, a translation of Madame Révillard. It's the final quotation on the sheet we found it in today, and it included Switzerland. So there's no doubt that those framing the convention regarded a declaration of trust as being included in putative Article 4. The only question was, what's the best wording with which to express it? We then go to 1575. So we're now at the 17th of October 1984, and we've got the draft which has come back from the drafting committee.
Sorry, page again, please.
And the page is 1575, my
Thank you
lord.
very much.
And what's happened, as your lordship has seen, there's been a vote that the question should go off for drafting, but there's been an emphatic endorsement that the declaration of trust is viewed as being properly included. Do we need to change the wording in order to make that clearer? Page 1575, bottom of the page, we've now got the text coming back from the drafting committee. 1576, second column, we've now got the reversal of Article 2 and Article 4. We've now got the convention taking its final form. Article 2 continues to use the expression placed under the control of the trustee. Article 4 retains the basic concept which had been under debate on the last occasion. Article 4 says this convention does not apply to preliminary issues relating to the validity of wills or other acts by virtue of which assets are transferred to the trustees. So the word instruments has been changed to acts, but apart from that, the drafting committee has decided to leave what is now Article 4 in its previous form. We go to page 1582. This was then debated on the 17th of October 1984. We're now almost at the end of the story. It's the story which wholly vindicates the von Overbeck report of paragraph 57. On the 17th of October 1984, there was a further proposal put in by Australia, Mr. Bennett now having had a conversion on the road to Damascus, as you'll see, the United Kingdom, Canada, the United States, and Ireland, a further proposal, in light of the fact that the wording had not been changed, to add to Article 4 the words, or set aside by a person to be held by himself as trustee. There's then a very important passage at 1583. Professor von Overbeck, the rapporteur, and it's the first passage which is translated on the sheet that we've handed to you today.
1583.
1583, first column. Now,
Yes, I see.
the reporter declares that the article has not, so to speak, been amended. The Commission had adopted the idea of replacing the word transfer by the word control in order to cover the declaration of trust. On reflection, the drafting committee realised that this term did not express the idea, that is, declaration of trust, better than the previous one. That's the idea. It is even clearer to speak of transfer. The words acte juridique have also been added to the French text. In the English text, the word instrument has been placed by the word act. So this is a very important passage, and with the greatest respect to the respondents in their narrative in Annex 2 to their case, where they say that we haven't told the full story in relation to paragraph 57 of von Overbeck, they do not draw attention to this passage. This passage, introducing the discussion of Article 4, makes absolutely clear that the drafting committee, which included Professors Hayton and Troutman, had decided that the idea, which had been voted in favour of 23-3, of the Declaration of Trust being within Article 4, was properly expressed by Article 4's existing language.
Is that a convenient moment, Mr. Green?
Well, maybe, yes. I've got about 2 minutes to go, but...
Well, then let's do the 2 minutes.
May we? I'm sorry.
No, it's really got 2 minutes, of course.
Then there's an interesting exchange. Mr. Waters asked, perhaps, basically said, well, so is a declaration by a settlor, would it be considered a preliminary issue under this article? So he's just asking for further clarification of what the rapporteur has actually said. I don't know why he didn't find what the rapporteur had said sufficiently clear, but he clearly didn't. And then there is a mysterious, we believe, a mistake or a misunderstanding. The chairman stated that he did not think so, and that the words other acts by virtue of which assets are transferred was intended to have a wider application than the previous formulation. Now, those words, he did not think so. Either the not is a mistake, or the chairman misunderstood the question, we would suggest, because it is wholly inconsistent with Professor von Overbeck's introductory remarks, wholly inconsistent with the whole genesis of Article 4, as voted on 23-3, in favour of the inclusion of the Declaration of Trust, for the chairman to have believed that the Declaration of Trust fell within the Convention. And that conclusion, that interpretation is further endorsed by what follows, because Mr. van Loon then said, let's take the following concrete example. An English citizen declares a trust with regard to a house located in The Hague, To give effect to this declaration of trust, he would have to proceed to change registration of ownership under Dutch law from his own name to himself as trustee. The requirements of Dutch law applicable to the transfer of registration would be included under Article 4. So it's quite clear, it's a preliminary issue, quite clear. Bottom of 1583, the chairman said, OK, it's adopted, and it's adopted in our respectful submission on the basis of a declaration of trust being included.
What does that mean as regards Dutch law? Does Dutch law recognise trusts then?
Well,
provided you make them express? Or what?
Well, no, it's saying that in order for the declaration, well, it's two answers to Lordship's question. It's saying that in order for a declaration of trust to be effective in Holland, for whatever purpose it may be effective, you have to comply with the formalities requirements of the law of Holland. You can't say, oh, well, I declared a trust which satisfies the formalities requirements of England. I'm home and dry. So that's that. And then here's a key passage, absolutely key
Another
passage.
key passage, right? Okay.
Well, it is, my lord, because it's also omitted by my learned friends in their response. What about proposal number 60, then, which was the proposal...
So where do we go?
Well, you saw at page 1582
Yep.
that the Australians in the UK had put forward some additional wording. That additional wording has not been debated. What's happened is they've actually voted to adopt Article 4.
Yep.
Peculiarly, then, as a matter of process, at page 1588,
Yep.
the chairman then says, towards the bottom of the first column, well, what about this proposal number 60? Look, we noted that we'd already adopted Article 4, he says. He noted further consideration of changes to this article will have to be preceded by a vote on a motion to reopen discussion.
Yeah.
Passage of this motion requires an absolute majority. At this stage now, Mr. Bennett is speaking in favour of adding the wording, but not on the basis that the wording, that the declaration of trust is not included. He just wants the point clarified. The chairman says, is there anyone else who's going to support a motion to reconsider? The Cypriot delegate steps up, and then there's a decisive intervention from the French delegate, which is the second translation. France declares that this problem at issue was discussed for 2 years. It concerns the declaration of trust. The committee considered that the words used covered the legal transfer to oneself in another legal capacity. This qualification was accepted by the two common law jurists and the members of the Secretariat. He thinks that discussions of this issue should now be suspended. Enough, he's saying, for goodness sake.
He was on the drafting committee.
Sorry.
He was on the drafting committee.
Was he? Yes, he was. Oh, was he indeed? Okay, oh, well, I'm obliged. He's saying enough. We've dealt with it. And in those circumstances, as you see, the absolute majority was not obtained. So it's quite wrong to suggest, as the respondents do, that there was any nuance about what was said at paragraph 57 of Von Overbeck.
Right, well, rather,
absolutely clear.
Echoing Mr. Barando, I think that's enough. We will resume again at 2:05. Thank you very much. Court's now adjourned.